Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about something very important: rescission of adjustment opposed to removal proceedings. Rescission of adjustment is an administrative tool that USCIS is entitled to if they believe that they issued a green card to you in error. And this error may be on USCIS part. Let's say USCIS mistakenly believed that you were entitled to the green card. They didn't check all the documents, or they made erroneous conclusion after you presented all the documents. Or it can be result of applicants' misrepresentation or fraud. It wouldn't really matter. The thing is, this rescission is a fast way for somebody to lose their status if there was in fact an error when they received their status in the first place. So how USCIS will really discover that error if they give you the green card before, and now they kind of forgot about you? Well, what happens is that usually such errors are discovered when person is filing for naturalization of citizenship, or person is trying to sponsor their relative, and person's file is going to be rechecked again for any possible mistakes. It is especially true for naturalization proceedings, as you can imagine, because especially nowadays, USCIS has to check if the person was qualified for the green card at the time that they received the green card. And if USCIS finds out that the person was not, they have options. They can either place the person in removal proceedings, or they can start the rescission proceedings. So how this rescission really works? According to the law, a person whose green card USCIS is trying to take away is supposed to receive a 30-day notice. A notice that says that you are entitled to present your arguments against rescission within 30 days of the notice. You're entitled to be represented by an attorney that you're paying for, not the government is paying for, in these proceedings. And if you do not reply within 30 days, we will just issue decision by default as if you never replied. So if you do reply, what's going to happen? What's going to happen is that then an immigration judge is going to have a hearing about the rescission. You will be there, the government and the immigration judge. The interesting part is that the law says that when USCIS makes a decision to nevertheless take your status away, that decision cannot be reviewed by the court. Okay. The only exception to that would be if a person did not receive a notice, that 30-day notice that the green card is going to be taken away, then the court has jurisdiction to review the decision by USCIS to rescind one's adjustment. Now, what's important to know here is that rescission applies only to adjustment. Is when the person gets the green card as a result of adjustment of status in the United States. It does not apply to those who received their green cards, immigrant visas, through consular processing. Let's say a person first receives their immigrant visa, and then they come to the United States, and then the green card gets to them by mail. So in this particular situation, the person will not be subject to this interesting statute. Why it's interesting is because, as you can imagine, when somebody is trying to take a status away, green card, it's very stressful. And usually when a person is in removal proceedings, the burden is on government to establish that person should be removed outside of the United States. But in rescission proceedings, the rules of evidence do not apply the same way. The standard, according to the law, is clear, convincing, and unequivocal. But we have not much information about the actual procedure, how it all happens. And if in removal proceedings, a person can file for waivers, let's say for various forms of relief from the removal, rescission proceedings limited to the issue whether there was an error or there was no error. Okay, so the rights are very limited. So let's say they did take your status away, okay, your green card. What happens now? What status do you have? Well, the law says that you're going to revert back to the status you had before the adjustment, and you will be considered an overstay with a visa that you overstayed, okay? Or maybe you didn't have a visa, and then you will go back to the status that you had before the adjustment. But the tricky part is this: if they take the principal's green card away, people who depended on the principal will lose their status as well. And that's what's not good about the situation at all. Because in removal proceedings, usually it doesn't happen. Each person has to be removed individually. So that's what the rescission is. This is how it's different from removal. Now, interesting part is this: the government can choose what they want to do. They do not have to initiate the rescission proceedings. First, they can place you in removal. They can place you in removal even though they have in mind the rescission. Now, the law says that the government has 5 years from the time they gave you adjustment of status to start these proceedings. But it doesn't work this way. Almost every court that looked into the situation stated that the government is not limited by this 5-year time limit. And only one federal court stated that the government is in fact limited by the 5-year statute of limitation, to my knowledge one. It's a Third Circuit federal court. Effectively, it means that the error was uncovered, let's say, in the Second Circuit, New York. 10 years later, the government can say, we're gonna rescind that adjustment, okay? But if you live in New Jersey, they have to put you in removal proceedings, where you usually have more rights. So that's very important to know. In general, of course, I do not really like this procedure because, as I said, rights are limited, but that's something to be aware of, especially if you were found to have an issue with your green card. Let's say you received the green card because there was an error with adjustment of status because you entered on a really fiancé visa, but the government thought it was some other visa, and they allowed you to adjust based on not on a petition by the original fiancé, okay? And now you filed for naturalization, and they discovered that there was an error, and now they're trying to fix it. Or you received a green card in an incorrect category. Let's say you stated you were unmarried, and in fact you were married, and that's how your case went down the drain, okay? So, as I mentioned, does not apply to consular immigrant statuses received through consular proceedings. Also, I believe that if somebody is placed in removal proceedings this way, they may be entitled to waivers, special waivers for those who were found to have misrepresented information on their adjustment of status applications. So it's basically the government here has discretion which procedure to use, how to use it, and it's, of course, it's better. That's why it's so important when you file for your citizenship, even though you may believe you have a very clear-cut case, to check with an attorney and to review your all prior immigration history to make sure that you're not going to uncover surprise. And you can read more about rescission on our website, www.shautsova.com. Thank you.